like to reserve 5 minutes for rebuttal.
That'll be fine.
Good afternoon, Your Honors, and may it please the Court, Daniel Sanders from Knoxville Bar here on behalf of defendant and appellant Jared Atkins. This case arises from a dispute about a property line and a spring. The trial court found that the appropriate property line placed the spring on Jared Atkins' property. The boundary line has not been appealed in this case. However, the trial court went on to rule that the plaintiffs have an implied easement to use of water from a spring located on defendant's property. This came as a surprise at the trial court level because the plaintiffs didn't seem to argue that they had water rights absent ownership. The defendant Atkins, Mr. Atkins, has appealed the ruling about water rights, contending that the trial court erred in ruling that the plaintiffs have an implied easement for use of the defendant's spring water, for failing to make findings of fact concerning the necessity of the implied easement, and in failing to strictly limit any implied easement to avoid increasing the burden on the defendant's property. On the first issue, we would request the court overrule and reverse the trial court. On the second two, we would request remand so that the court can make appropriate findings or limitations to the easement. Both parties have cited Selco Partnership versus Shelby County for setting out the three elements of an implied easement. In this case, the plaintiffs had a burden of proof. One, that a separation of title occurred. Two, that prior to the separation of title, the use giving rise to the easement was long established and obvious or manifest as to show that it was meant to be permanent, as distinguished from temporary or occasional. And third, a required element is that the easement be necessary for the beneficial use and enjoyment of the land granted or retained. As a practical matter, Your Honors, finding an implied easement requires the court to do some drafting that the original parties to the conveyance failed to do. The express policy of the state is to limit these implied easements. In fact, the Selco court said that the law doesn't favor these easements, and the courts of the state have an express policy in favor of restricting the use of the doctrine. So that policy of restricting the use of the doctrine requires the court to resolve disputes or uncertainties regarding the scope of the easement, and narrowly. The implied easements must be confined strictly to the purposes for which they were granted or reserved. It's always a facts-intensive determination. Here, in this case, prior to 1979, the plaintiffs and the defendants' properties were part of the H.E. Nicely Senior Farm. The farm was comprised of parcels 84, 84.01, and 84.02 on the Granger County tax map that is entered as Trial Exhibit 1. Now, the disputed spring is located on the defendant's property in this general area, and if you can see from the blow up, there's a property corner here and then the spring head down here on the defendant's property. The general configuration of the properties is, we'll start down here. There's a railroad right-of-way here. There is the plaintiff's property up here. This is Nicely, and then the defendant's property down here. This is Mr. Atkins. The property line runs down a hollow, makes a jog, and then extends to the railroad right-of-way line here. On the other side of the railroad right-of-way line is property that is currently under the record ownership of Peggy Nicely. This is a blow-up of Trial Exhibit 12, which was the survey relied on by the trial court to establish the boundary line. During H.E. Nicely Sr.'s ownership of the farm, he and his wife Murdy lived with their daughter Peggy Sue in the Nicely home place on what is now parcel 84. Water to the Nicely home came from a spring on parcel 84.01, indicated here by the spring head, through a 1.5-inch gravity-fed pipe. The pipe ran from the spring through the culvert under the railroad to a house on the west of the railroad, parcel 84. At some point prior to 1979, H.E. Nicely Jr. and his wife Betty Lou built a house on parcel 84.01 that is currently owned by Mr. Atkins. In 1979, H.E. Nicely Sr. divided his farm between his children, Peggy Sue and H.E. Nicely Jr. Peggy Sue Nicely acquired parcels 84 and 84.02, and H.E. Nicely Jr. and his wife Betty Lou acquired parcel 84.01. The warranty deeds used to divide the Nicely farm did not mention the spring or any easement for the use of the water from the spring. Plaintiffs acquired their property from Peggy Sue in 1992 when Peggy Sue sold 84.02 to the Niceleys and retained ownership of 84. Mr. Atkins acquired his parcel in 2016 from Betty Lou Nicely, who was the widow of H.E. Nicely Jr. The trial court in this case issued an oral ruling that was incorporated into a final judgment. The court relied on two items of proof that supposedly support plaintiff's implied easement. The first was the last will and testament of H.E. Nicely Sr. that was executed in 1978. As noted by the trial court, the will speaks at death. Mr. Nicely Sr. survived until 1983, well after he divided his farm between his children in 1979. While the will mentions use of water by Mr. Nicely's children, it didn't convey title. It is not in any relevant chain of title, and it cannot serve as a basis to notify anyone of an express or an implied easement. The second item of proof relied upon by the trial court was this 1.5-inch gravity-fed pipe that ran from the spring across defendant's property and under the railroad to the Nicely home place. Under Selco, these two items may very well support... Yes, Your Honor.
Clear this up for me. Was the trial court trying the issue of the boundary line only, or was it trying the issue of the boundary line and whether or not that there was an easement regarding the spring water?
Your Honor, there were separate findings, and the trial court's oral bench order was clear on that. He went through the boundary line found in favor of the boundary line Mr. Atkins proposed. And then he switched gears and he said, there's also this issue of water, right? And then when he went into that portion of his oral order.
What I'm getting at, was that initial issue that was presented to the trial court that was tried, the issue of the water?
Your Honor, we did not request that relief. The plaintiffs did not request that relief in their complaint. Like I said at the beginning, they did not seem to argue that there was an easement to the water or a right. They have a right to water without ownership. When the court entered into that monologue about the spring water rights, he started to read part of the complaint, and then he read part of our our answer that requested general relief. It was certainly not a specific item that we requested. Ultimately, Your Honor, we think under Selco, neither of these items of proof establish an implied easement. First, a 1.5-inch water line that runs from the defendant's property across under a railroad to a 1-acre parcel may very well establish an implied easement to the Nicely home, but at no time were there any obvious or manifest structures or artificial creations that took water from the spring to parcel 84.01. The plaintiffs have argued in their response brief that there is an agricultural need for that water. However, all of the portions of the brief they cite to the record indicate that there is a right maybe or a need for the water maybe to the spring, or the stream or the branch, which was mentioned during the trial.
Show us, if you could, here from where the spring is and where the branch runs.
This property corner, there's a detail. This circle is a detail of that
Yes.
property corner.
Yes.
The property corner is here, and the spring head is here, just inside the defendant's property line.
All right.
This property corner.
Does it show the branch?
The branch.
that runs?
This property corner is uphill from the branch. The branch extends from a culvert under the railroad right-of-way up the defendant's property, then runs this way across the plaintiff's property, and then generally follows the property line up through a hollow.
All right, that's the branch from the spring.
Yes, Your Honor, and you can see here it says approximate center line of branch right here. And
All right, so the branch runs on both the defendant's property
Yes, Your Honor.
and on the plaintiff's property.
Yeah, this is the plaintiff's property, nicely. This is the defendant's property. This is the property line here, dash line. The branch cuts across the corner.
That's the branch, that line right there.
Yes, Your Honor, that's the branch, and it cuts across the
So it
corner.
cuts
of the
across the
plaintiff's
corner
property
onto
there.
plaintiff's land.
Yes.
Okay.
I have reserved time for rebuttal.
Yes,
so
yes, you have your time for rebuttal.
Thank you, Your Honor.
Hear from the appellee.
Thank you. May it please the court, I'm Jim Eastep from the Claiborne County Bar. To continue with that, in the reply brief of the appellant, there is a page with a diagram showing the branch, and it's darkened for you all. In this case, Your Honors,
I'm correct in my understanding now that the branch runs, I guess, mostly on defendant's property, but it does cross the corner there on the plaintiff's property.
Yes, Your Honor.
All right.
It does. The original, and Your Honor, the McClarty, the original pleadings did not request the court to issue or decide any issues as to the springs. It was a boundary line dispute. Subsequently, in the trial, during the trial, there was testimony about use of the spring, use of the branch, the 1.5-inch pipeline that went to Peggy Sue Nicely's property, who owned the Atkins property in total after the division in 1979 by her father, in which the remaining section, now owned by Mr. Atkins, was divided off between the two siblings. We go further in the trial, and at the end, on the day of the trial, a counter complaint was filed by the defendant, the appellants, and Chancellor Fogarty addressed at that point the prayer under 2914-102 to decide the other issues that may remain, and particularly addressed the spring in those findings, those verbal findings that he issued at the trial. In those, he said that the court stated that Henry Sr. and Murdy were already using water at the time the division was made. That's the 1979 division that ultimately ended up with my client and the appellant. He said at that point, Peggy was my predecessor, owned all of Tract 84 and 84.02, that she was to have those rights to use water out of the spring. He also addressed in this finding the will that was executed in 1978 before the deeds were done in 1979, but prior to his passing in 1983. That will was used as some evidence, or as evidence of where the spring was located. But that will, which is Exhibit 8 in the trial, also discussed water rights. And in that will, it provided that water rights basically to one side and the other, and didn't really define, except in one phrase near the end, I think it was paragraph 3 of the will, that Peggy Sue would have the rights to the water from the spring that's located on Henry Jr.'s property. So, although it didn't convey title, it was used by the chancellor, and it was evidence as Exhibit 8 in the trial as to the intentions of the parties of the original predecessor in title. So we go from 1979, when the division occurred, and then my clients purchased in 1992 and from Peggy Sue Nicely. It primarily it's in the Washburn community of Granger County. It's primarily rural agricultural land, and it was used for cattle production, some running of cattle, some hay, and to the Peggy Sue Nicely house. And it continues to her house today, that 1.5-inch water line. That's her source. Now, we don't own that house. But she owned it all prior to us. We own the tract of land adjoining the appellees. This spring that we're talking about, the dispute was whether or not whose property it's located. We disagreed.
I'm still confused. I'm not sure how we started out at trial court with what was a boundary line dispute to determine where the spring was located. And we ended up with that determination, which nobody's appealed. Also a determination by the trial court about this easement. I mean, did both of you, and I'll ask both of you at the same time, do you both agree that that was tried by consent? I mean, apparently it wasn't raised in the complaint.
It wasn't raised in I'm sorry.
I asked both of you, so.
It wasn't raised in the complaint. I wasn't a lawyer at the trial. I'm just a lawyer in the appeal. From my review of the record, it appears that the issue as to the spring was the primary issue for the boundary line. There wouldn't be necessarily, I don't think there would be a boundary line dispute if there wasn't a dispute over who's entitled to this spring or who owned the spring. So I think it was tried somewhat by consent, but I can't really say or be confident in that answer.
You tell you what, we'll wait and let you respond in your rebuttal, if you would, and
all right,
rather use his time.
But in any event, it appears that through the trial, the court wanted to resolve, and I think rightfully so, with these through TCA 2914-102, he resolved all the issues concerning the spring, and particularly the boundary line of the properties. Now, both sides have had cattle production. There's been obviously there has been use of the spring by both sides. We think there's testimony in the trial, particularly Roger Collins, where he discusses the use by both sides. And their predecessor had the whole farm. He used the spring, obviously, to the property. So there is the use, and we think under the facts and the law that the decision of the chancellor should be upheld.
Let me ask you, I miss Judge Goddard when boundary line disputes are up here, because he always used to love them and would volunteer to take every boundary line dispute, because Judge Goddard loved boundary line disputes. But what was the proof in the record that shows the necessity for the use as to the water?
Well, the use of the water was the cattle, the agricultural purposes.
All right. Was there any proof that, and the record may tell me, I haven't gotten that deep in it yet. Is there any proof as to whether or not there was a spring house over the spring, or was it just open, or what was the situation?
There was I think there's some form of cover, but there's a water box. The water box serviced the Atkins side of the property. Herbert Nicely Jr. and Betty Nicely were the predecessors to Mr. Atkins. The spring, a line ran from the spring to a water box, and then there was a pipe from that. For the Peggy Sue property, there was a pipe actually out of the spring to her tract of land.
And the brook that we've talked about runs from the spring,
Yes,
and it runs across your client, at least partially, I mean, it's on your client's property for part of the time.
it is.
Was there any proof as to the cattle were not, that the brook was not what they were drinking out of, as opposed to the spring?
I think there was both. There is one statement by Roger Collins that I believe he said they were drinking from the spring. Primarily the testimony was the drinking from the branch. You don't want your cows drinking out of your spring.
No.
Then you've got the issue of contamination.
All right, then my question to you is if the brook is on your client's property, at least a portion of it is on your client's property, why can't the cattle drink out of that?
Oh, well, they can. The issue becomes
what's the easement to?
Well, the ability to run a pipe to a trough
From the spring
from the
directly?
spring.
Okay.
And there's testimony that there was water to a trough, maybe one sentence, but there is one sentence to the trough, to water to a trough, and that's how you would get it, would be from the spring.
You couldn't get it from the brook?
That you couldn't, because the trough is more than likely going to be higher than the branch.
Yeah. Okay.
Gravity comes into play.
Yes. All right.
I'm an expert. I've got a spring that I get my water to my house from. Thank you, Your Honor.
Yes, we'll hear from the appellant in rebuttal.
I think you picked up. Thank you, Your Honor. To your point, there was testimony about, I believe this was Betty Lou Nicely, and it's in Volume 3, page 185. Question was there a fence to keep the cattle out of the branch? There was just a little wire fence around the spring to keep them from getting in the spring to drink. And you're right, Your Honor. You don't want your cattle drinking from the branch or drinking from the spring. And I would submit to you that there is a big difference between taking water directly from the spring for cattle and allowing the cattle to drink from the branch or the stream that runs on both pieces of property. In this case, there is ample testimony about cattle drinking from the branch or the stream. Of course, to the more specific point, if it's a stream that runs across both pieces of property, then the element of necessity is all but missing. So, what are the elements of this cause of action, and how do they apply to the facts of the case? In 1979, when this property was divided, there was that 1.5-inch water pipe that ran from the spring down to the house. Perhaps that was long established and permanent, but at that point under Selco, any implied easement that might give rise to has to be narrowly confined to the purposes for which it was created, those obvious and manifest purposes of getting residential water to the Nicely house. There's no proof in the record that Peggy Sue Nicely ever engaged in any obvious
that water pipe to the house is not really in dispute here, is it?
No, Your Honor. I don't think it is.
That's parcel 84. It runs to parcel 84.
Parcel 84. Our surveyor prepared this document that you see here. It's Trial Exhibit 12. That's page 1 of Trial Exhibit 12. When he went out there, he discovered the water pipe. Now, the water pipe is marked with a W, and it extends from the spring head, showed in the detail, down across the defendant's property into the railroad culvert and to the Nicely house on the other side. Now, whatever might be said about getting water to the Nicely house, Peggy Sue Nicely never had any way, pipe, aqueduct, other conveyance whatsoever to get water up to the tobacco barn or the tobacco fields or any other use on parcel 84.02. In fact, there was testimony at the trial from both sides. We mentioned Roger Collins. Roger Collins testified, and this is cited specifically in our brief, Peggy Sue never had a pipe or anything to get water up to to the property that she owned above the railroad, and that's parcel 84.02. And then Betty Lou Nicely also testified that Peggy Lou never had a pipe or anything to take water up toward the tobacco barn. There were water boxes that were located on the defendant's property because the trial evidence shows that when H.E. Nicely owned both tracks, he kept stock on this property. There was a stock barn down here somewhere, and then he had a tobacco barn on this property up here. So there's no proof that Peggy Sue ever had any obvious or manifest way to get water up there. This fact also implicates this bona fide purchaser way that the court can limit the doctrine of implied easements. In 2016, when Mr. Atkins went to the property, there was no pipe or no indication that the plaintiffs who owned the property at that time made any use of water from the spring. And so with that, we claim that Mr. Atkins took this property free of any implied easement. He had no notice of it. There was never any intention that anybody intended cattle to be drinking from the spring. And we would ask the court to reverse the trial court. We'd also ask you to look at those additional alternative arguments about the findings of fact and the failure to apportion the easement. Thank you.
Okay. Court thanks both sides for your arguments today and your briefs on this. If you would, adjourn court till our next regularly scheduled docket.
All rise. This court stands adjourned until Tuesday, February the 14th at 9:30 a.m.